Hi, everybody. Attorney Yana Feldman, your Brooklyn, New York-based estate planning and elder law attorney. Today, I want to talk to you about a question that almost every single one of our clients asks. What's the difference between a will or a trust? Today, I have a few talking points that I'm going to walk you through so you can learn about the difference between a will or a trust and start thinking about what may be right for you. So, the first difference between a will and a trust is going to be summarized in one word, and that word is probate. Probate has become a dirty word. It's not very fun. It is the process where a will is submitted to the court. I'm going to walk you through this. It might get a little bit messy because probate often is messy. After someone passes away, the executor of the will has to file the will along with a petition for probate with the local surrogates court. That petition has to lay out who are all of the people who are named in the will, and then also who are all the people that would inherit if there was no will. Now, all of these people either need to sign a waiver or the court will schedule a date at which they have an opportunity to come in and be heard. And the executor, or usually the executor's attorney, has to basically give each of those people an invitation to show up and potentially contest the will. We have to serve them with a notice of citation. So obviously that process is going to take a little bit of time. Once that citation day comes, the judge will wait and give an opportunity for people to come and contest the will. If nobody does that, and you can prove that everyone has been properly notified, then the judge will take the matter under review, and your loved one's will and paperwork goes into a pile on the judge's desk to eventually be reviewed and processed. Assuming everything goes smoothly, you've crossed all of your T's and dotted all of your I's, the court will in fact approve the will and authorize the executor to begin the process of collecting assets and paying out debts. Now the estate has to stay open for 7 months in order to allow all creditors to present their claims. After 7 months, the estate can be distributed and closed. You can imagine there are often things that slow the process. Unfortunately, we have cases where someone has passed away 2, 3, 4, even 5 years ago. And even though there's no litigation, no one's actually fighting about anything, these matters still have not been resolved and the beneficiaries still have not received their inheritance. A lot of times it's because the will wasn't drafted properly, or maybe it wasn't signed properly. But in any case, probate can be a very lengthy, painful, and expensive process. Phew, that was a lot. And probate can be a lot. It can be stressful and painful and expensive. So remember we were talking about the difference between having a will and having a trust? There's one of your huge differences. When you have a trust that's properly drafted and properly funded, but we'll talk about that another time in another video, your family does not need to go through the probate process. In fact, the trustee of your trust could distribute assets to beneficiaries immediately after your passing. Now, there are some small formalities that we like to observe, but the bottom line is if there's someone that financially relies on you, assets are going to be available for them virtually immediately after you pass away. And that's a huge benefit. A few other advantages of trusts besides avoiding probate. Number one, privacy. When you have a will, that will is filed with the court And virtually anyone could stroll into that courthouse and get a copy of the probate file, know what your assets were and who you left them to. A trust, on the other hand, is a private document. It is not filed in the court. So you can be sure to eliminate the worry that people are going to be nosing around in your personal, confidential, financial issues. In addition, a properly drafted trust could, depending on the type of trust, provide asset protection for yourself during your lifetime or for your beneficiaries. Again, with privacy, discretion, economy, and of both time and money. So the differences between having a will or a trust can be huge. You've gotten some ideas. I hope I've tantalized you with some of the benefits from having a trust-based estate plan. The next step should probably be to speak to your attorney or to one of our attorneys about what kind of estate plan could benefit you and your family. So when you're ready, pick up the phone and give us a call.